So welcome to this, the fourth webinar in our series on cyberbullying, cyber hate, and online harassment. This webinar is organized by myself and Dr. Angela Mazzone. We are postdoctoral researchers at the Observatory on Cyberbullying, Cyber Hate, and Online Harassment, which is based in the DCU Anti-Bullying Center. The Observatory is funded by the Irish Department of Justice and Department of Education. So today's webinar will focus on cyberbullying from legal and psychological perspectives. And we are joined today by two excellent speakers, Dr. Tj Mcintyre and Professor Dagmar Strohmeyer. So first we will hear from Professor Strohmeyer before we hear the talk by Dr. Mcintyre. And then we will open up the floor for anyone who has questions towards the end of the webinar. And please write your questions in the chat box in the side of the screen. And you can do so throughout the webinar, and then we'll look at all your questions towards the end. Right. So now I would like to welcome Professor Dagmar Strohmeyer. Dagmar Strohmeyer is professor at the University of Applied Sciences, Upper Austria, and professor at the Norwegian Center for Learning, Environment, and Behavioral Research in Education at the University of Stavanger in Norway. Between 2021 and 2022, she was a guest researcher at the University of Turku in Finland. She holds a PhD in psychology from the University of Vienna in Austria. Professor Strohmeyer studies peer relations in children and youth with a cross-cultural and cross-national perspective and a special focus on immigrant youth. She has developed, implemented, and evaluated a program to foster social and intercultural competences in schools known as the VISC program that has been implemented in Austria, Cyprus, Romania, Turkey, and Kosovo. She was the principal investigator of the EU-funded project Europe 2038, which examined young people's engagement with the European Union in 7 countries. Professor Strohmeyer was awarded Researcher of the Year by the University of Applied Sciences in 2011 and received the Bank Austria Main Award for the support of innovative research in 2009. She served as co-editor of the European Journal of Developmental Psychology between 2015 and 2021. Professor Strohmeyer has published numerous peer-reviewed journal articles, edited 7 special issues of peer-reviewed journals, and 2 books. Currently, she is president of the European Association for Developmental Psychology. So we are delighted to have you with us today, and I will hand it over to you now, Dagmar.
Thank you very much for this really nice introduction. I hope you can hear me very well. So please just tell me that everything is fine. Okay. I am really happy and very honored, of course, to be invited to be a speaker today. I have a very long-lasting collaboration and friendship with Angela Mazzone, who actually was also a guest researcher in Austria, in Linz. This is Linz, my office in the background. So she knows exactly where I am. And it's really nice, of course, also Maya, to get to know you. And I'm really happy that you have this very nice webinar series. I think it's a great initiative and a good thing to have. So it's really a very innovative format, and even now after the pandemic, it's probably a very nice way of having people like me, because I could not come to Dublin and share my knowledge with you, but now it's of course very easy. So do you see my slides? Can you hear? Can you just tell me whether you see my slides?
Yes.
Okay, because I'm in the presentation mode, so I don't see you.
All right.
So just I have only one screen, but now everything works, so it's fine. Okay, I would like to give you an introduction into the phenomenon of cyberbullying. And I would like to start with the nature of cyberbullying and cyber victimization. So I will also focus a little bit on the definition. What is the phenomenon? Then I would like to talk about some theoretical approaches, the dynamics, risks, and protective factors. My presentation is based on a paper that I have recently published with my other very nice colleague, Petra Gradinger, who is an even bigger cyberbullying expert than myself. So if you like, I have also sent this paper to Maya and Angela. You're very welcome, of course, to read this paper. It was published in the journal European Psychologist, I think, beginning of this year. So the date is 22, I think, but it was probably January or February. So the bullying definition is nowadays under debate, but the scientific community very much agrees that bullying is something like a subcategory of aggressive behavior that is characterized by repetition, power imbalance, and hostile intent. So we are following basically the first definition of bullying that was developed by Dan Olvius. And later on, another very big name in the bullying field, Peter Smith, made the first definition of cyberbullying. And basically, it's the same idea as the offline bullying, but here the difference is that the aggressive or mean intentional act or behavior is carried out using electronic forms of contact. So in the research field, basically the difference that really distinguishes the offline bullying and the cyberbullying is the electronic forms of contact. And we have this feeling that there are really otherwise quite a lot of overlaps, and also in the definition. When we now think about what kind of behaviors could cyberbullying and cyber victimization cover, to begin with, of course, I need to say cyberbullying is the thing that a person is doing. So it's the perspective of the perpetrator, and cyber victimization is the perspective of the victim. So when I say cyberbullying, usually I mean a perpetrator, and when I say cyber victimization, I mean the target, the person who is suffering the negative behavior. So what can be done? Very many things can be done. So messages can be sent via smartphones or with laptop, photos, videos can be produced and sent and shared. It's also possible, of course, to exclude a person from social network sites. For instance, very common is that there is a WhatsApp group or there is a Signal group. There is a group somewhere of maybe peers, and one person is not invited, maybe because nobody likes him or her, or some person really wants to intentionally exclude this person. That would be an example of social exclusion. But it's of course also possible that there are some like verbal attacks or even physical threats that are delivered online. So this is not a single type of behavior, cyberbullying, but I think it consists of a very broad range of possible behaviors. And I believe that it's not even possible to have a list of all possible behaviors, because as soon as we have a list of behaviors, maybe there is a very clever perpetrator and he or she finds another type of behavior. So I would not define the cyberbullying based on the concrete behavior. I would rather say it's really the electronic form of contact, and it's the bad intention, hostile intention, it's the repetition, and it's also the power imbalance, in a sense that the victim feels or the target feels that it's impossible or very hard to escape or to help yourself. So that's the kind of feeling from the victim perspective, that it's hard to escape. Certainly, when we talk about cyberbullying and cyber victimization, especially when we are coming from offline bullying and offline victimization, there are several complexities. So my understanding of the phenomenon is that this is much more complex than offline bullying, because there are several features of online forms of contact or electronic forms of contact that make this behavior more complicated. I think already in an offline setting, it's very difficult to really know whether it's a hostile intention or not. So this is not always easy to judge. And I think in the cyber environment, it's even more difficult, because maybe a perpetrator says, no, I didn't on purpose exclude him or her from the WhatsApp group. I just forgot him or her, or it was just not relevant that he or she is involved. So it's very clear that there could be a big discrepancy in the perspectives of the perpetrator versus a target or a victim, in a sense that a target feels excluded and has a strong impression, oh, this is really a pattern. So it's not only an accident, there seems to be something more behind it. While a perpetrator might say, no, this is just an accident, this is just fun, I didn't mean it. So it's really hard to judge the intention, both in the offline and in the online environment. But also the power imbalance is something that is not even easy to fully understand offline, but it gets so much more complex in a cyber environment, because the power can also come from a technical know-how. For instance, a person who would maybe never be a perpetrator in a real world setting, maybe because he or she is really a very soft or very small boy, for instance, in a group of very big boys, he might have a technical know-how, and therefore he is maybe able to really perpetrate something online as a perpetrator that would never happen in a real world setting. But also the anonymity is a potential problem, because if a person has good skills of media, then it's maybe easy also to hide their own identity or to change the identity, to use fake names in the internet, and that makes it much more stressful for the victim. It's much more stressful for a target that gets harassed if he or she doesn't know who is the one who is doing this. The repetition, of course, it's a very complicated and maybe the most complicated thing. It's already hard if you get picked on a regular basis when you go to school. But at least there are some hours during the day, at least when you are at home, where you are not at school, and then you are safe. But in the online environment and in the cyber world, the smartphone is with you 24 hours, 7 days per week. So it's really hard to escape. And the feeling that this harassment is more or less following me, if I'm a target, makes for me this whole behavior tremendously stressful. There is the other thing that is completely stressful from a target's perspective, that is that even one act could be multiplied like indefinitely often, because even if one perpetrator is posting one naked photo of me, let's say, I'm not sure whether this could be erased completely, and maybe even after years this photo will reappear because it had been shared somewhere, it was saved somewhere. So unfortunately, it's really hard to get rid of the information that is once out in the internet, because it's a kind of uncontrollable who is saving and sharing these contents. On the other hand, of course, it's also easy and possible when young people know the technology to block perpetrators. So it's also easy to collect the evidence. So to make a screenshot and to prove that something negative is going on, that's also much more easy in the internet. So in a way, also, if a victim is killed, he or she can also collect evidence, maybe he or she blocks the perpetrator, or maybe if nothing else helps, he or she can also change the profile name, delete the old Instagram profile, for instance, makes a new one, and then maybe not invite this person as a follower anymore, or even like unfollow, like delete the person from seeing your private profile, for instance. That's also possible. So, but anyways, there are many complexities, and I would really say that it's a very interesting phenomenon, of course, from a scientific point of view, because it's so complex. And here we just summarized all types of complexities. So cyberbullying has several forms. It can be verbal, it can be social exclusion, there can be photos, there can be videos, there can even be some tone songs or some spoken things. There are different modes. It can happen in social networks, it can happen on web pages, it can happen on messages, it can happen via calls, it can happen also in online games. So I think online games is a really important mode, especially for boys, according to the newest studies I'm aware of, especially when it's about boys. They play a lot of online games. They often also have online gaming communities, and bullying happens in these online games. So for boys, this is a tremendous important dimension. For girls, it's also important, but girls don't play so much compared to boys. Privacy is also a very big topic. An insult or a bullying can happen between two people, then we have a dyad. It can happen in a closed group. It can also happen in an open group or an open profile, and then potentially everybody could see the harassment. And of course, from a target perspective, this privacy matters, because if there is a shameful photo about me, maybe it's okay if it's in a dyad. Maybe I can also easier cope if it's a closed group, but it could stress me very much if I have the feeling everyone can see this forever, and it's very hard to delete it at all. So that could really stress the target very much. Also regarding the motives, there is a complexity. Why are perpetrators bullying others, or why do they cyberbully? So very often it's because of power. They want the power. The power imbalance is the thing that they want and they desire. They also want a status, so they want to be liked by others or admired by others. Very often they want to belong. They want affiliation. Also, it's sometimes because of a hot emotion about anger, so then it's revenge. Anger is a motive by itself, and also in the cyber context, the perpetrators say, oh, it was nothing, it was just fun. So there is also a group of perpetrators who is not even aware that this is harassment, that this is wrong, that this is harmful for some person, because they believe this is fun. Regarding the devices, I would say we have a very interesting situation, because it always depends on the technology development. When I started with the cyberbullying research, there were no smartphones. So smartphones were not yet developed. So we had the mobile phones. We had some people who had a lot of money, they had laptops, and others, they had computers. But nowadays, of course, we basically all have smartphones. So the device also is a kind of measure that cyberbullying can be transmitted, because nowadays all of my social contacts and my social network apps, they are all on my smartphone. And probably if new things are going to be developed, that will also change the options for being a target or a perpetrator of cyberbullying as well. And then there is, of course, the other important thing that is definitely also tremendously important in the internet, and this is the bias. So bias-based cyberbullying is nowadays a very big topic in research. And I think it's also extremely important topic for the offline bullying, but maybe it's a little bit easier to perpetrate racist, sexist, or other bias-based negative behavior online than in the face-to-face context. Therefore, this is an extremely important aspect for cyberbullying. So there are these many dimensions of diversity dimensions, we can say, that make people more vulnerable to be a target of cyberbullying. And the most important dimensions are written on this slide. So it's race, gender, ethnic group, nationality, disability, sexual orientation, poverty, religion, appearance, but certainly there are even more. And there are really interesting studies showing that there is an effect called the online disinhibition effect. So it's easier for perpetrators to penetrate the bias like in a more anonymous online setting than in a face-to-face setting, and maybe therefore it's also a very, very relevant thing in the online world. And this is even more devastating, of course, for the target, because it is like targeting your whole being, your whole way of being, and it's not possible to change the race or the gender or the nationality. Even if you have another passport, often you are perceived as a non-national person anyway. So that's a very, very tough thing. And in the research, basically cyberbullying research developed not so much based on a theoretical model, but it more developed based on practical needs. So it really came from schools and it came from education, and teachers and students reported these behaviors to researchers. But later on, the psychology tried to find some theoretical perspectives that fit to this phenomenon. And there are basically two main theoretical models that are also quite complementary. And maybe even in some points, they're even a little bit contradictory, but I would say they are more complementary than contradictory. So the first model is the general aggression model. This is a social cognitive personality theory that aims to understand how individuals develop an aggressive personality. So here, the focus is really the question, why is this person a perpetrator? Why does this boy behave aggressively towards others? And in this model, it's a socio-cognitive approach. So it's about knowledge structures, perceptions, interpretations, decisions. And later on, there is the behavior. So this is not a behavioral theory. It's more a cognitive, socio-cognitive theory, and therefore all these antecedents before a behavior is carried out are in the focus of study. The second important framework that is now, I would say, the more dominant one in the offline bullying field is the Socio-Ecological Framework. And here the focus is not so much on the aggressive personality, but this model aims to understand person and environment interactions on different levels. So basically, while the first model focuses on the head of the perpetrator, zooms into the cognitions of the perpetrator, the second model wants to better understand the environment and how is an environment shaped that a perpetrator is able to perpetrate and perform the cyberbullying or the bullying behavior. And this is really a very prominent model, and the kind of the generated wisdom in this field would suggest that it's not the environment alone, it's not the personality alone, but it's about complex interaction effects. So a person in a certain environment behaves in a not good way. Maybe he or she perpetrates the cyberbullying, while the same person in a different environment would not do this. And so here we have options for interventions, because we can also change the environment, and we don't need to change the head of the people. Even this is also possible, but maybe it would need some therapy or some very, very targeted psychological interventions. And just for you to see this, the general aggression model I summarized in the slide before. So it's a kind of, as I said, it's a kind of social information processing theory. It's a very like computer thinking, because we have inputs, we have situational factors, we have roots, we have proximal processes, then we have decision making, then we have the cyberbullying encounter, and then we have outcomes of the cyberbullying encounter, maybe depressive symptoms if you are a victim, or delinquent behavior if you are a perpetrator. So it's a very complex model, and all these aspects, well, not all, but many of these aspects have been studied. The model for the socio-ecological framework looks a little bit differently. Here, the main model is the onion. So the onion is the layers. So a person, for instance, a bully, a victim, or the dyad of the bully and the victim, they are embedded in social groups, in social contexts, and they have names. So for instance, they are the microsystem is the family, another microsystem would be the classroom or the school. Then we have a mesosystem that would be the interaction, for instance, between family and school. Then we have the exo level, that's the community. So it's the city maybe, or the district of the city where a person lives. And is this a poor district? Is this a safe district? Is this a disorganized district? Or is it a very organized and very well functioning district? And the last and the most far away layer is the culture. That is, of course, very, very difficult to grasp, but nevertheless, it's important, because definitely cyberbullying is a historical phenomenon, and cyberbullying especially has been caused by the technical developments. So without having internet, without having smartphones, without having laptops and computers, the phenomenon would not even exist. So here, of course, there is a historical and cultural dimension, but it's very, very far away. But for the research and also for the intervention, this structuring of the environment in different levels can help a lot to better see where are the possible risk factors and the protective factors that could be changed to reduce the cyberbullying, but also the online bullying. And now I come to the risk and the protective factors. So we are in a very good position at the moment, because there have been really a lot of studies conducted during the last 20 years in this field. So we have a very big knowledge base. Of course, from a scientific perspective, it's never enough. Even after 20 years of research, we could do even better as researchers. So most of the studies are unfortunately cross-sectional, so one time point measurement. So there is a limitation in the interpretation of the results. So we cannot know about the temporal order of the phenomenon. We cannot know about causes. What is the cause? What is the consequence if we have only one time point studies? But still, nowadays, there are several reviews available and meta-analysis available. And from a scientific point of view, a review, a systematic review, and also meta-analysis is an extremely good knowledge base. So it's a very, very strong evidence. So I will show you in the next slide. There are meta-analyses where you have more than 100,000 young people summarized in the study. And no single study probably is able to do this. So it's a very good synthesis of the available literature. And based on this really good scientific evidence, what are now the risk factors? That is the thing maybe that we should consider or take into consideration if we want to avoid cyberbullying in our schools, and if we also want to avoid cyber victimization. So for cyberbullying, so for the perpetrating of the behavior, a very big risk factor is being a victim, being the perpetrator of offline bullying, and also being a victim of offline victimization. So being a target of offline victimization. So cyber bullying and offline bullying and cyberbullying with victimization, both offline and online, they correlate very, very much. So it's not very often that a cyber perpetrator is just a perpetrator in the internet. It's rather so that he or she would also be a perpetrator in the real life. Then older age, also the older the adolescents are, the more frequent they use the internet, the more. Moral disengagement is an important factor. Normative beliefs about aggression. So when aggression is thought about something normal, anger, risky online behavior, but also narcissistic behavior, narcissism was a risk factor. Cyber victimization, there were similar but also different risk factors. Here again, we have offline victimization as a risk factor and offline bullying as a risk factor, not cyberbullying in this case. Then we have frequency of internet use. So the more a child or an adolescent use the internet, the more likely he or she gets victimized. So it's opportunity. The more opportunity, the more possibilities. Social anxiety is a factor. Again, moral disengagement, risky online behavior, again, anger and hyperactivity. So this is a very strong evidence because it's based on these very many studies. We have also some longitudinal risk factors. There was another nice meta-analysis. It was published just 2 years ago. So here we see again that longitudinally cyberbullying and cyber victimization are moderately associated with each other. So cyberbullies are often also cyber victims. So those two behaviors go together. And the most common pattern in these longitudinal studies was that cyberbullies are often also offline bullies, and that cyber victims are also often offline victims, and that the offline behavior comes first. So we are not knowing whether it's the cause, but in a temporal order, offline is first and online was afterwards. And another interesting aspect is also that offline bullying is more stable over time compared to cyberbullying and cyber victimization. So being a cyber bully and a cyber victim also changes. So it's a more dynamic phenomenon. And I would say it needs to be also studied a little bit with more short time spans, because it seems to be more dynamic. Maybe because people have coping strategies like blocking, changing identity, and so on and so forth. There were also some meta-analyses regarding developmental patterns. And the most studies I reported now, they cover adolescents between 10 and 15 years old, so early and middle adolescence. And basically, I would really say there is a lack of studies on children that are younger than 10 years. And this is a very big and a very unfortunate research gap, because mediatization and the possession of smartphone, and with the smartphone is the internet access, follows a developmental pattern. So there is a really nice study showing that 35% of the 6-year-olds, 52% of the 8-year-olds, 79% of the 10-year-olds, and nearly all, 94% of the 12-year-olds use the internet regularly, and they have a smartphone. So it means that if we are not investigating in our research the younger, the 10-year-old children, we omit that they can also be the perpetrators and the victims of cyberbullying. And my last slide, and then I am basically in time with my half hour, it's about prevention and intervention. I just wanted also to give some ideas about that. So in the field of cyberbullying, we have two types of approaches. So programs with a narrow focus on cyberbullying, or we have whole school anti-bullying programs. And the literature shows that both of the approaches are effective. And what is the difference? The prevention programs with a narrow focus, they usually focus the media competencies. So they try to train students less risky online behavior. They explain that they should have private profiles. They explain that they should not meet strangers online. They explain how to protect themselves from harassment online, maybe by not sharing too many personal information or not posting shameful photos. Like I could also post a stupid photo of myself, and if I do it, maybe some other person makes fun of it, that could be avoided. So this is media competencies. And the whole school anti-bullying programs, they are focusing on the not bullying others aspect, so on the social competencies. And they are also very effective for cyberbullying and also cyber victimization. And we have meta-analysis on this topic, but of course, still a lot of research is still needed, because we don't know in research yet which aspects are the ones that are the most effective. So we don't know whether it's the talk with the bullies, whether it's the empathy training, whether it's the group discussions. So there are different elements in those programs, but we don't know which are the ones that are most effective or that are really needed. And that is certainly something for future research. And if you like, my talk is based on this publication. And in this publication, I have of course put all the references. In this talk, I didn't put so many references. So if you are interested, you can easily look at this paper and find more things to read. And for now, I thank you very, very much for your attention. And I hope that you have some questions for me later on, and I will give the floor to the second speaker. Thank you very much.
Thank you so much, Dagmar. That was such an interesting talk. I'm sure there will be lots of questions for you. So remember, everyone, you can put your questions into the chat box, and we'll have a look at them towards the end of the webinar today. So thank you again, Dagmar. Now I would like to welcome our second speaker, Dr. Tj Mcintyre. Dr. Mcintyre is an associate professor and head of teaching and learning in the Sutherland School of Law at University College Dublin. His research focuses on issues involving information technology law, cybercrime, and civil liberties. He holds a BCL from University College Dublin, an LLM from University College London, and a PhD from the University of Edinburgh. His doctoral thesis was on the topic of internet filtering law and governance. He qualified as a barrister in the Honourable Society of King's Inns in Dublin, where he achieved the Antonia O'Callaghan Prize for Advocacy, and was later admitted as a solicitor by the Law Society of Ireland. He's also a member of the New York Bar. Dr. Mcintyre practices as a consultant solicitor with FP Logue Solicitors, specializing in data protection and technology law issues. He's a specialist adjudicator for the .ie Alternative Dispute Resolution Policy. He is a chairperson of the civil liberties group Digital Rights Ireland and regularly appears in the national and international media discussing issues of law and technology. Since 2010, he has been the Irish national expert on information society and data protection issues for the EU Fundamental Rights Agency Research Network. Today, Dr. Tj Mcintyre will give a talk on cyberbullying from a legal perspective. He notes legal responses to cyberbullying tend to fall into three basic categories: civil action by victims against harassers, criminal prosecutions against harassers, or duties on intermediaries such as social network providers to monitor users' activity and remove posts or take other action against users who harass others. This presentation outlines how each of these responses operates in practice and the legal issues which they present. So TJ, I will hand over to you now.
Many thanks. I'd like to give you, if I may, a slightly more practical and less theoretical response to the topic. As you mentioned there are, broadly speaking, three categories of legal remedies that are available to individuals who've been the victims of cyberbullying. I want to talk about how these operate in practice, how they might be developed in future, and the desirability, or I think the lack of desirability, of using the law as a tool in this area. So first of all, let's think about civil actions. What are the actions that individuals themselves who've been the victims of cyberbullying can take against those who harass them online? There's a number of well-developed areas of law here. You can think about defamation law, when somebody says something about you online that's not true. You can think about harassment, where somebody persistently engages in harassing conduct against you online. You can think about data protection law, where somebody reveals information about you in a way which they're not entitled to do. And there's a long line of cases in Ireland and elsewhere where individuals have taken action against those who've harassed them online using these tools. So if this is such a straightforward thing to do, if it's such a straightforward area of law, why is it problematic? Well, the most obvious answer is that it is a slow and difficult process. It's not suitable for the overwhelming majority of cases. And in fact, most of what you describe as bullying, many of the things which Dagmar has described in her presentation, aren't actionable as a matter of Irish law. So simply saying nasty things about somebody online, unless it's sustained over a period of time and it reaches quite a high threshold, doesn't qualify as harassment, and it certainly doesn't qualify as defamation. That's the first problem. The second problem is one of cost. So the courts in Ireland are not cheap. You will be doing well to come away with change from several €1,000 from a single day in the High Court. And if you want to bring an action against somebody for this kind of online abuse, very often you may have to spend several days in the High Court. The reason I say the High Court is this, that in these kinds of cases, very often you need to identify the person doing the abusing. And that means you need to get what's called an Pharmacal order, which is an order from the High Court, which is directed to, for example, Twitter, asking them to reveal the identity of somebody behind a particular account. Now, very often you need a number of those orders, because Twitter may come back and say, well, we can't tell you who this individual is. All we know is that they created the account, or that they logged in to the account from a particular IP address at a particular time. So to link that IP address to an individual, you will then need to go get a second Pharmacal order against the internet service provider who owns the IP address. You will, for example, have to go to Virgin Media and say, somebody's been posting nasty messages from this IP address at this time. Can you please tell us who that subscriber is? What's the home address? What's the name on that account? So before you actually get as far as bringing an action against the individual, to identify the individual, you've brought one, possibly two applications in the High Court at a cost of several €1,000, and you're still only at the start of the process. Now, let's assume that's not an issue. Let's assume we know who the person is behind a particular course of online harassment, and let's suppose we want to take an action against them. Well, another problem is that even if we don't have to go through the cost of identifying them, the cost of bringing an action, even in some circumstances in the slightly cheaper jurisdiction, circuit court, is still going to set you back several €1,000 at a very, very, very minimum. And Ireland has, in theory, cost shifting rules, loser pays rules. That is to say, if you lose a court action, you have to pay the costs of the person who wins the court action. That, of course, assumes that the person who loses has the money to pay. And practically speaking, and certainly when we're talking about cyberbullying in a child context, we can't assume that. If it's an adult doing the bullying, perhaps they have a home and you can execute against that home in respect of your costs. If it's a child, well, you're out of luck. Another problem in these cases is that if you do have to identify somebody, you may need to look for an order against a service provider which is based overseas, and you're dependent on them being willing to play ball. Sometimes they will, sometimes they won't. And if they choose not to engage with the Irish legal system, then practically speaking, there's very little you can do. Now, there is one exception to this general picture of gloom, and that's in the area of data protection. In some cases, if you can show that your data protection rights are being infringed by a course of harassment against you, for example, if images of you are being posted online or information about you is being posted online, in some cases, if the provider isn't willing to help, you might be able to go to the Data Protection Commission, which might be willing to intervene on your behalf and direct that the provider stop posting that particular information about you. However, the Data Protection Commission regards itself as having a discretion as to what complaints to address, and in practice, it very often won't take up these kinds of complaints. So you're not guaranteed a remedy in that way either. So those are some of the difficulties if we think about private action being brought by individuals against harassers. What about state action, specifically criminal prosecutions? What's the scope for this to serve as a remedy? Well, there's a very well-established line of cases and series of laws which, although they weren't initially designed with online harassment in mind, have since been applied against online harassment. In fact, if you go back to 1999, that was the first year in which there was an Irish conviction for harassment on the internet, where an individual posted material alleging that a school teacher had sexually abused him. So this is by no means a new area of law. And the law in this area has in fact been substantially overhauled quite recently. The Harassment, Harmful Communications and Related Offences Act 2020, better known as COCO's law, has updated the law in this area. And there's now three major classes of offences to be aware of. There is an offence of harassment, there is an offence of sending threatening or grossly offensive communications, and there's an offence of recording and distributing intimate images. And each of these is practically quite important. So the harassment offence makes it a crime to persistently harass somebody by any means, which includes online, by doing a number of things, including communicating with them or communicating about them. So the threshold of gravity here is persistence. Once-off actions aren't covered. But if you persistently send messages to somebody or post messages about somebody, that is capable of constituting an offence. And that's quite a significant offence for a number of reasons. As a practical matter, it's a very useful offence because if somebody is convicted, the court can make an order restraining them from contacting the victim or doing other things, for example, staying out of a particular area of town. And in fact, in some circumstances, even if an individual is acquitted, the court can nevertheless say effectively this conduct is so egregious that the victim should be protected against it and can order that this conduct not be repeated into the future. So the harassment offence, as updated quite recently, is practically very significant. It's very significant as well because it doesn't just cover communications to somebody, the threatening phone calls, abusive phone calls, silent phone calls, emails, text messages, what have you. It now also potentially covers communications about somebody. For example, the typical situation where somebody falsely posts that another person is interested in sexual encounters, puts their phone number on a website and invites other people to contact them. That would also constitute harassment under the offence as recently amended. So it's that's one offence, and it covers many of the categories that would come under the cyberbullying discussion we've had so far. Another offence is the offence of sending grossly offensive communications. So under Coco's law, we have a new offence of sending communications which are either threatening or grossly offensive. And it's an offence you can commit in one of two ways. You can send a threatening, grossly offensive message to somebody, or you can distribute or publish a threatening or grossly offensive message about somebody. So again, this differentiation between messages to and messages about. And it's an offence to do these things where you do so for the purpose of intentionally interfering with somebody's peace and privacy or causing that person alarm or distress. Now, this is, to a large extent, overlapping with the harassment offence, but it's somewhat wider. One of the main reasons it's wider is that it covers one-off communications. The harassment offence is an offence which is committed where a defendant does something persistently. This is wider. It covers one-off communications in some circumstances. Unfortunately, it's a very vague offence. The intention is clearly that it would capture cyberbullying, and particularly when you think about talking about somebody, sending communications about another person which are threatening or grossly offensive. But the difficulty is it doesn't actually define what's meant by either threatening or grossly offensive. And to the extent that it doesn't do so, it seems to be very likely that it's unconstitutional. There have been a series of cases where that kind of formula, it's a very vague formula, that making it a crime to say things about somebody else which are grossly offensive, were found to violate free speech guarantees. For example, in 2014, the New York Court of Appeals found a similar law to be overbroad. In 2015, the Nova Scotia Supreme Court in Canada found a similar law to be unconstitutional, contrary to their Fundamental Rights Charter. And in 2016, also, the Supreme Court in India found almost exactly the same formulation, so gross offensiveness, to be so vague as to be an unconstitutional restriction of freedom of expression. So the problem with that part, I think, of the 2020 Act, and one of the reasons why it's useful to mention here, is it illustrates a problem with lawmaking in this area, which might be very well intentioned. It might be intended to protect children, but very often it's not fully thought through, where you don't define what's meant by threatening, where you don't define what's meant by grossly offensive, where you criminalize talking about anybody, not just children, bear in mind. These are laws that apply across the board to everybody, adults included, where you criminalize talking about people in a way that's grossly offensive. Then on the face of it, you have, I think, a provision which is likely to be used to restrict freedom of expression. The Canadian case on their similar law is quite instructive, because that was a case involving one businessman trying to use a similar provision to silence criticism by another businessman. It literally did not take a year from the passing of the law before somebody was trying to use it to silence discussion, legitimate investigation of their business interests. So that's one real problem here. When you have these very broad, arguably overbroad laws, they can very easily be abused to silence investigations generally. One of the suggestions from the New York case was that if you're going to have this kind of law, that it should be tailored so as to restrict it to children. There's no justification for having a similar law restricting what's said about adults. And that, I think, is an important point that is yet to be reflected in this kind of legislation. If I can move on then, the third category of offences that we have in Ireland at the moment are the so-called intimate image offences. These were introduced for the first time by Coco's law, and they create offences not just of taking intimate images, so taking photographs of people without their consent, but also offences of distributing or publishing those images where that seriously interferes with their peace and privacy or causes them alarm, distress, or harm. And Crucially, it also gives anonymity to victims. It entitles victims to be anonymous in any subsequent criminal prosecution. This is quite wide. It includes, in some circumstances, deep fakes, so manipulated images, which are intended to make it appear as though somebody is nude. And it's obviously, I think, a very desirable advance in Irish law. Again, unlike the harassment defense, it captures one-off publications, which is important. Then on top of that, you have, of course, the wider criminal law, threats to kill or cause serious injury, blackmail, in some circumstances, certain kinds of racially motivated and abusive speech. And all of these can be prosecuted in the normal way as well. So we have a reasonably wide set of laws here to protect people. They apply in the online context. What's the difficulty with applying them in a cyberbullying context? Well, the starting point is the, I think, very often overlooked question of, do we actually want to be, again, particularly in the child context, do we want to be criminalizing children? Is the criminal law an appropriate response? So the trend in criminal justice generally is to try to take children out of the criminal justice system, is to recognize that it's not suitable for them. And it's not suitable more generally as a tool for managing and regulating behavior. It's slow, it's expensive, it's cumbersome. Sometimes it can be there can be a difficulty once you involve the criminal law in a process. It makes it harder to resolve it at the level of the school or at the level of the family. And so in a child-centered context, I think the criminal law isn't necessarily appropriate. Another problem is that police resources in the area of cybercrime generally haven't been adequate in Ireland. In the last few years, you've seen several year delays, up to 6 years of a delay in prosecuting very, very basic offences involving child sexual abuse images. These are cases where a laptop has been seized from somebody, where there's child sexual abuse material on that laptop, but the prosecution hasn't taken place for 3, 4, 5, 6 years after the laptop was seized, because the police lacked the resources to actually forensically examine the laptop and bring a case in what is fundamentally the simplest kind of case you can have. There was an attempt to respond to this in 2016 when the Garda National Cybercrime Bureau was established. We've seen resources for the Cybercrime Bureau increased significantly over the last few years. The most recent figures I have give us 45 Gardaí in the National Bureau in Dublin, 4 regional hubs established in Cork, Galway, Mullingar and Wexford, with between them approximately 20 Gardaí, and some civilian experts being hired as well to try to get through some of the digital forensics backlog. However, a problem here is that we don't have robust research. In fact, we don't have any formal research that I'm aware of on how Gardaí respond to complaints of online harassment, which might amount to an offence. But anecdotally, we hear an awful lot of cases where individuals have gone to a local Garda station to be told that there's nothing the Gardaí can do. Even in cases which I would say are clearly criminal, they've been told that there's no power to investigate, this is a civil matter, or that they won't get involved where the bullying is taking place on a platform that's outside the jurisdiction. So it certainly seems to be the case that the training in this area is very ad hoc, and that we need more consistent training for guards across the country, and not just those in specialist units in respect to this sort of crime. Where they do investigate these crimes, there's also a problem in relation to actually getting evidence. If you can get evidence from a device, a phone or computer that's seized, that's one thing. But very often these cases require evidence from, for example, Facebook in California. A problem here is that Ireland isn't part of most of the international instruments that are used to get access to digital evidence held abroad. Ireland hasn't ratified the Cybercrime Convention from 2000. It's failed to take part in the European Investigation Order. The Irish implementation of mutual legal assistance treaties is quite slow. And in cases that we know of where Gardaí have used the mutual legal assistance process to get access to data held, particularly in the US, we know that there are very significant delays taking place at that stage. So again, while you have relatively strong substantive laws, procedurally speaking, it's quite difficult to implement them. We need to see a focus on the kind of procedural changes that and training that would enable the police to do that. Again, with the caveat that a criminal justice response, just like a civil law response, isn't necessarily an appropriate one to deal with the case of children in any event. Finally, then, we had the question of the duties on intermediaries. What must intermediaries do in relation to, for example, taking down posts or suspending users who harass others? So traditionally, the law in this area was one that gave intermediaries quite a passive sort of position, where under the e-commerce directive of 2000, they faced possible liability if a complaint was made to them about something which was illegal and they failed to do something about it. But otherwise, if they weren't put on notice by a complaint, then they didn't have to proactively do any monitoring or take any other steps. And we saw then in the last decade or so, at the beginning of a change there, where some national laws started imposing significant penalties on firms where complaints were made to them by state authorities in particular about certain material which was illegal, and they failed to take it down very quickly thereafter. So the German network enforcement law, the Netzstücke, is the best known example of that. But that still kept this basic passive role of the intermediaries in place. It meant, again, that intermediaries, platforms such as Facebook, social media sites such as Twitter, were responding to complaints coming in from state bodies or third parties and acting on those complaints. They weren't necessarily doing any active investigation or actively designing their systems to make it easy to report these complaints or to respond to them. Although one innovation there from the Netzstücke in Germany was that it did improve the reporting process. It required firms to make it easier to highlight how something was contrary to the law. At that point then, to the extent that firms were monitoring and taking down posts and other material proactively, it was down to corporate self-interest rather than legal obligations. And very often the corporate self-interest meant that the complaints process was slow, it was underfunded, they mightn't necessarily have moderators who could speak a particular language, and so on. Now, the trend in the last few years is to impose greater duties on providers. And there's two laws in particular here I want to mention. At a European level, you have the Digital Services Act, which requires that hosting providers and other entities have to provide greater accessibility to complaints. They have to provide complaints mechanisms. They have to act promptly on complaints. They have to notify people when posts have been taken down, etc., on the basis of complaints. They have to provide for internal appeal mechanisms against decisions to remove or not remove content. And it also allows for out-of-court dispute settlement bodies where an individual isn't happy with the response of a particular platform to a particular complaint. If you are a very large entity, a so-called very large online platform or very large online search engine, you have additional duties under the Digital Services Act, including duties to carry out risk audits, identify systemic risks resulting from your services, which can include risks to minors from using your services, and then to take steps to mitigate against those risks. So this is potentially very significant in terms of requiring firms to build in at the design stage into their systems greater mechanisms for complaints about individual posts, tools to protect children, and so on. However, at this stage, the Digital Services Act has only just been agreed. We don't know how in practice it's going to be implemented. And in particular, we don't know how these kind of risk identification audits might work and what firms might do on foot of them. At an Irish level, you have the Online Safety and Media Regulation Bill, which is currently before the Oireachtas. It's very hard to comment on it since it's a long, very convoluted piece of legislation. It is very likely to be changed significantly before it's passed. To some extent, it's in conflict with the Digital Services Act. It was introduced before the Digital Services Act was finalised, so it's very likely to be changed significantly to better mesh with the Digital Services Act. So I don't really want to make any firm predictions as to what it might look like in its final form. But one of the things that the OSMR bill does is introduce new rules in relation to so-called harmful online content, which would include content which is intended to intimidate or humiliate or persecute. In other words, some of the content that would fall under our discussion about cyberbullying from earlier on. And it would require firms to have safety codes in relation to preventing and removing harmful online content. It would introduce a requirement for firms to have complaint mechanisms in respect to this. It would open up the possibility of individuals complaining to the firm to have this content removed, and if the firm didn't act on that complaint, then complaining to a media commission, which is a state body to be established under the OSMR bill, which could then direct that the content be removed. Now, so far, this might all look very like the EU position. A significant change, however, I should flag. The EU position under the Digital Services Act is about removing illegal material. The Irish position under the OSMR bill would be one of requiring removal of harmful material. That is to say, not necessarily, and in fact, in most cases, probably not illegal. And again, you run into very significant freedom of expression concerns here, where the kinds of material which individuals might find humiliating, bearing in mind that this isn't merely restricted to children, it applies to everyone, includes, for example, cartoons published about politicians, or investigations into the conduct of businessmen. So if Dennis O'Brien, for example, who's one of the most notorious litigants in Ireland, felt that a particular investigation was intended to persecute or humiliate him by exposing something that he had done, then on the face of it would be open to him to use this complaint mechanism to say, I have been targeted by this, and potentially to demand that material be taken down. So again, you have a concern here that these very open-ended terms, which aren't sufficiently well defined in the legislation, go well beyond material which it would be illegal to publish about somebody because it's defamatory, for example, or it's in breach of data protection law, but they get into these very subjective definitions or subjective interpretations as to humiliation, persecution, and so on. And I think they are very problematic. Certainly, I wouldn't be confident that if they were legally challenged, that they would stand up to that. But in any event, perhaps it might be a little bit misleading to think of either these provisions of the OSMR bill or even the Digital Services Act as being solutions in any general sense to the problem of cyberbullying. I see a lot of people placing a lot of hope in these mechanisms as a tool for dealing with cyberbullying. I'm very skeptical of that. You have to bear in mind, these are mechanisms to address individual discrete pieces of online content and to say that this is illegal for the following reasons, this is harmful for the following reasons, and therefore this particular item should be taken down. Both pieces of legislation aren't really about wider systemic duties. To a small extent, the DSA addresses this in a way which the OSMR bill doesn't in quite the same way, but they're not about wider systemic duties in any event of protection against cyberbullying. They're not about dealing with, if you like, patterns of behavior which might overall result in an individual feeling that they've been bullied. For example, as Dagmar identified, the exclusion. They're about discrete pieces of content which can be, for the most part, they're about discrete pieces of content which can be identified as illegal or harmful. And even if they might be successful, therefore, in helping you to address particular complaints that this particular photo of me is bullying, this particular piece of information about me is bullying, this particular blog post about me should be taken down, they don't really address the issue of wider patterns of behavior. And therefore, I think it's very misleading to focus on them as being a possible solution for cyberbullying. To summarize then, the law as it stands does have a lot of individual tools to address the issue of cyberbullying. It does have some individual remedies available for people who have been victimized. Overall, though, I think the cost, the bureaucratic overhead associated with legal remedies in general makes it an undesirable mechanism to focus on. And I don't think that we should waste the resources that we have in trying to achieve remedies through the law, which ultimately I think are unlikely to succeed. Ultimately, I am a lawyer, and much as I love lawyers and I think lawyers are great, and I'd love to see more business for lawyers, and I'm sure any lawyer in this seminar would love to profit more from more laws. I'm very skeptical in this case that more laws are the solution. I think I can leave it there. Thanks.
Thank you, TJ. So I think we can stop recording. And yeah, so I thank you so much for your excellent talk. I really appreciate